All right, if you've ever lived in a community with a homeowners association, you know the rules can be, well, a bit of a battleground. But this story isn't about mismatched mailboxes or lawn gnomes. This is about what happens when an HOA breaks its own rules. So get ready, because this is a classic David versus Goliath story where one single homeowner took on the entire association over just one word. So this is really the heart of the matter, isn't it? It seems like a simple question, but believe it or not, the answer actually took a formal state hearing to sort out. Ultimately, though, it all boils down to this. Does an organization have to play by its own rulebook? Let's meet our main players. On one side, we have John Krahn, a homeowner, and on the other, the Tonto Forest Estates Homeowners Association. Now, the dispute wasn't over something super dramatic, like a crazy construction project. Nope. It was about one very specific rule for a single committee. But as you're allowed to see, the principle behind it, it's huge. Okay, this right here is the core of the entire case. We're looking at the community's official rulebook, the CC&Rs. And Article 5.3 seems pretty crystal clear, right? The architectural committee shall consist of 3 regular members. The whole legal battle, everything, it all hinges on that one little word, shall. So, here's the thing. Mr. Krahn's complaint wasn't a matter of opinion or how he felt about something. He was alleging a simple, verifiable fact that the HOA's architectural committee was running with only 2 people, which is a direct contradiction of the rule we just saw. So let's dig into the homeowner's side of things and see how he built this case. Now, Mr. Krahn wasn't just any homeowner. He'd actually served on the board before. He built his entire case not on emotion, but on the HOA's very own records. In his opening statement, he just cut right to the chase. He basically framed the whole thing as a simple yes or no question. Did the committee have 3 members like the rules say, or did it not? He was betting that the evidence, the facts, would be completely undeniable. And how long had this been going on? Well, according to the homeowner's testimony, which was based on the HOA's own documents, the committee had been operating with fewer than 3 properly appointed members for a staggering 42 months. That's 3.5 years. This timeline, built from the HOA's own paper trail, really tells the whole story. The board knew they had a vacancy. Mr. Krahn volunteered the very next day. Months go by. Then, the community manager even confirms it in writing, still only 2 members. Now look closely at that last date. It was only after the formal complaint was filed that suddenly the board appointed a 3rd member. That timing, well, it's everything. All right, but there are always 2 sides to every story, so let's pivot and take a look at how the HOA defended itself. Their argument wasn't really about denying the facts, but more about how you should interpret the rule itself. The HOA president, Dwight Jolivet, he argued from a place of, tradition and practical reality. He basically testified that, look, no board in the past has ever thought that a temporary vacancy meant the whole committee was suddenly illegal or had to just stop working. And right here, this is the entire legal fight in a nutshell. It's a battle over one single word. To the homeowner, shall means must. It's a command. To the HOA, it's more like a strong suggestion, something with a little wiggle room. The HOA's position was basically, look, it's just not practical to shut down the committee every single time a member leaves. They insisted they were actively trying to find someone new, and that letting the other 2 guys keep working was a reasonable interpretation of the rules, and in the best interest of the community. So that's where we are. 2 totally different interpretations of the exact same rule. You've got one side armed with the literal text and a paper trail, and the other side arguing for practicality and tradition. It all came down to an administrative law judge to weigh the evidence and make the final call. And the verdict? It was decisive. The judge sided with the homeowner. David beat Goliath. The ruling was clear. The HOA had, in fact, violated its own governing documents. So why did the homeowner win? This quote from the decision is the key. The judge looked at the facts on one specific day, February 5th, the day the complaint was officially filed. And on that day, the committee did not have 3 members. End of story. Appointing someone later didn't go back in time and erase the original violation. The final order kind of lays out the consequences. The violation was officially confirmed, yes, and the HOA had to pay back the homeowner's $500 filing fee. But notice that last line, no civil penalty. The judge basically said you broke the rule and you have to fix it, but we're not going to punish you any further. It was a victory on principle. So, a homeowner wins a dispute against his HOA. You might think, big deal, right? Well, what's the bigger picture here? This case actually offers some really powerful lessons for anyone who lives in or helps run a community with shared rules. So what are the big takeaways from all this? First, that rule book, it is not a suggestion box. The literal text is what matters when push comes to shove. And that word shall, yeah, it means must, period. Trying to fix a problem after you get caught doesn't make the original problem disappear. But I think the biggest lesson of all is that one person, with a clear paper trail and the facts on their side, can absolutely hold a big organization accountable. And that leaves us with one final, pretty thought-provoking question. This entire dispute, which cost people time and money, it all happened because of a disagreement over one single sentence in the rulebook. It really makes you wonder, how well do the people governing your own community actually know the rules they're supposed to be enforcing?